Courts have made it more and more difficult to defend against Ponzi clawbacks. There's even evolved a theory called the Ponzi Presumption, which provides clawback law, makes clawback law even more unfair if that were possible. A Ponzi presumption means that if a trustee convinces a judge to grant a Ponzi presumption, then the trustee is relieved from meeting most of his legal obligations, his legal burdens. It's like starting a poker game and giving the trustee 3 aces instead of random cards. The first ace is that with the Ponzi presumption, the trustee does not have to prove fraudulent intent on the part of the alleged Ponzi perpetrator. This is very, very, very important. Typically, in a fraudulent conveyance case, the trustee would have to prove by circumstantial evidence using something called badges of fraud that the alleged perpetrator had a fraudulent intent. In other words, when he paid you your profits or your fake profits, the trustee must normally prove that the perpetrator knew and intended to defraud you with that at that time, or those were fraudulent payments, either to defraud you or knowledge that those were fraudulent payments, he was defrauding somebody else. But with the Ponzi presumption, the trustee can skip all that. The fraudulent intent is presumed, and the burden of defense shifts to the defendant. The second ace is that a defendant typically must show that he gave reasonably equivalent value in exchange for the payments. But many courts seem to apply the Ponzi presumption even to the reasonably equivalent value requirement and conclude that because it's a Ponzi scheme, a defendant cannot, as a matter of law, have provided reasonably equivalent value for so-called fake profits. The courts do not characterize this necessarily as part of the Ponzi presumption, but it's often simply stated in conclusory fashion without any analysis. By denying a defendant the ability to prove reasonably equivalent value, a defendant will have a very tough time defending a fraudulent conveyance case involving receipt of so-called fake profits in the context of a Ponzi scheme or alleged Ponzi scheme. The third ace is that the Ponzi presumption seems to often lead to a presumption that the debtor was insolvent at the time of the transfer in the context of a Ponzi scheme, so that the trustee doesn't have to prove that either. Typically, in a constructive fraudulent conveyance case, the trustee is going to have to prove insolvency. Here, he doesn't need to do that either. The theory is that a Ponzi scheme is by definition always insolvent because it has no real assets, only debt. If the trustee does not have to prove insolvency and there cannot be reasonably equivalent value, then of course it's very, very difficult to defend a constructive fraudulent conveyance case in the context of an alleged Ponzi scheme. So why is all this a problem? The main problem I have with the Ponzi presumption is that the fraudulent conveyance laws should not even be used in the first place to claw back fake profits. The trustee will argue that the purpose behind these clawbacks against innocent investors is to redistribute assets so that investors and losers are all treated equally. Well, they've all been victims and they should all be treated equally in the same class. The first problem with that argument is that the fraudulent conveyance laws were not created to redistribute funds equitably. That's not their purpose. All the history of the fraudulent conveyance laws show that their purpose was to bring back assets into the estate that were transferred out prior to the bankruptcy, either fraudulently or negligently. The purpose is to bring back assets for all creditors, losers and winners, not to shift assets from one creditor victim to another creditor victim. Congress drafted the preference laws for the specific purpose of ensuring an equitable distribution of assets among similarly situated creditors. These preference laws exist. The very existence is predicated on the theory that no one creditor should get preferential treatment before the bankruptcy. But Congress gave trustees a 90-day window for those clawbacks. Payments made within 90 days before bankruptcy should be clawed back. The window is short for a very good reason, because the result is so harsh on innocent preferred creditors who are forced to return money that they received to pay legitimate debts. If Congress wanted to allow trustees to sue under the preference laws to claw back Ponzi money that was paid many years prior to the bankruptcy filing, paid to innocent creditors, they could have and they should have extended the 90-day look-back period to 3 years, 5 years, or 8 years, or whatever. But they didn't do that. They didn't extend the look-back period. They certainly knew about Ponzi schemes, but they chose not to. Or they could have extended the look-back window just for Ponzi schemes. They didn't do that either. We have three branches of the government. It is the elected legislative branch that is charged with making those changes to the law, not the judicial branch. Second problem I have is that the theory of the Ponzi presumption has been expanded and applied very broadly in cases where the business arguably was not a Ponzi scheme, or only later became a Ponzi scheme. Courts have defined a Ponzi scheme, generally speaking, as a scheme that is not a real business and that has its model the payment of earlier investors by money received from later investors. It's a scheme that will inevitably fail. The court should be very, very careful about applying the Ponzi presumption, which is very powerful, to situations involving a real business that may well have succeeded but failed due to business decisions and not necessarily fraudulent decisions, and then afterwards the manager tried to cover up losses and engaged in fraud and became fraudulent later. This is a very, very important distinction. If early investors received money before the business became a Ponzi scheme, it's extremely unfair to apply a Ponzi presumption that relieves the trustee of proving actual fraud in that particular payment to that particular innocent investor. There may have been no fraud involved whatsoever. In that early situation, it could well be that the profits paid to that early innocent investor did not come from later investors, and that the failure of the business was not inevitable. In these situations, the Ponzi presumption definitely should not apply. And yet some courts do apply it in that situation. An innocent investor should not be allowed, should be allowed to prove reasonably equivalent value. The reasonably equivalent value is clearly present. The value is the investment capital which should have been invested elsewhere, which could have been invested elsewhere, and earned a reasonable risk adjusted return. Ponzi's are extremely destructive, and many, many people lose their life savings in this horrible way. However, it is extremely misguided to create thousands of new victims or re-victimize innocent victims in the name of justice and fair play.